you, Jeff. Hi, my name is Courtney Buchan. I am the corporate trainer for GRS Community Management. I'm also a licensed CAM and a board member myself. So a little bit about GRS. We've been providing great, reliable service since 1989. We service all of Florida in all facets of community management, HOAs and condos. So if you're happy with your community management service, I'm happy to hear that. But if not, you can definitely check us out at our website at grsmgt.com. Big thank you to Kay Bender Rembaum for always hosting these classes with us. I always enjoy working with them. Peter, thank you so much for doing the presentation. So I don't want to take up too much time, so I'll pass it over to you.
Okay. Thank you, Courtney. And hi to everybody who is watching today, listening today. As Jeff mentioned, this is a condominium legal update for the continuing education credits. Interesting enough, it's very close to what the legal update is, because just by coincidence this year, most of the legal changes were done to the condominium statutes and the condominium law as opposed to other portions of the law like HOAs. As Jeff mentioned, I am an attorney here with Kay Bender Rembaum. I have been practicing community association law for a very long time, since 1984. So entering my 42nd year coming up. I've done both sides of the street. I've worked for developers and I've also worked for associations, mostly for associations though, for the bulk of my career. And I'm Florida Bar Board certified condominium specialist and in plan unit development law. All right, so that's enough about me. So we're going to start the presentation. I'm going to try to get this done in an hour or so, a little over. By the way, Kay Bender Rembaum, we are a full service community association firm. Okay, so we're going to start with managers and management companies and associations. Basically, they have changed the law with respect to manager licensing, the penalties for being suspended or revoked, conflict of interest, and online requirements. Okay, as far as penalties, any licensed manager or licensed community association manager, which is an LCAM, if you've had your license revoked, you cannot have an indirect or direct ownership in or be an employee or a partner, officer, director, or trustee of a management firm for 10 years, for the 10-year period after the effective date of the revocation of your license. You're also ineligible to reapply for certification or registration as a licensed manager for a period of 10 years after the license has been revoked. You also are required to create and maintain an account with the Department of Business and Professional Regulation, which oversees community associate managers. So managers and management firms must create and maintain an online licensure account with the DPPR. Managers must identify the firm for which they provide management services and identify which associations that you are the designated on-site manager. Managers and potentially management firms must also update this online information within 30 days after any change to the required information. Management firms must identify on their online licensure count the managers or the LCAMs that it employs. And if a manager has their license suspended or revoked, the department must notify both the management firm and the association that the manager works for, or that the manager is providing services for. Professional standards and with respect to contracts entered into between managers, management firms, and associations. Okay, so managers and management firms, you cannot knowingly perform any act directed by the association if such act violates any state or federal law. So again, knowingly. So if the manager or their management firm knows that what they're being directed to do violates state or federal law, then the manager or the management firm cannot do that. So it's a knowing violation. If a manager or management firm has a contract with an association that is subject to the milestone inspection requirements, and we'll talk about that in a few minutes, or the structural integrity reserve requirements, we'll also talk about that in a few minutes, the manager or management firm must comply with those requirements as directed by the board. Every contract or each contract between an association and a manager or a management firm must include certain language in at least 12-point type, if applicable to the type of management services provided. That language is the community association manager shall abide by all professional standards and record-keeping requirements imposed pursuant to Part 8 of Chapter 468 Florida statutes. Part 8, Chapter 468 is the section of the law regarding manager licensing. Okay, a contract between a manager or a management firm and an association may not waive or limit the professional standards imposed by that statute. Okay, conflict of interests. So basically, what we're talking about in a little bit of detail is that anytime that you have a manager or a management firm entering into a contract that may be a conflict of interest with respect to the association, there are certain disclosure requirements that come to play. There's certain bidding requirements that also come into play. So we'll talk about that in more detail now. And also previously under Section 468.4334, subsection 3, that only applied to HOAs, not condominium associations or co-ops, but now it applies to all associations. So that being said, managers and management firms are now required to fulfill the statutory obligations for all associations, not just HOAs. And among these statutory requirements under Chapter 468 is they must attend at least one association meeting per year, and that's either a board meeting or a membership meeting, owner meeting. They must provide the members of the association and post on the website the name and contact information of the manager assigned to the association, and provide to any member upon request a copy of the contract between the association and the manager or the management firm. Now, those contracts, by the way, besides this law, are part of the official records of the association. So additionally, under just the Condominium Act or the HOA Act, but we're talking about condos today, the management contract must be provided to an owner upon request anyway. All right, conflict of interest. As I mentioned, we're going to talk about that. An additional rebuttable presumption that a conflict exists has been added to the statute. So now a rebuttable presumption that a conflict of interest exists is if an LCAM manager or management firm proposes to enter into a contract or other transaction with the association, and it is clarified that the contract or other transaction is for services other than association management services. So if a manager or a management company is going to perform services under a contract other than management services, that's a presumed conflict of interest. In lieu of listing all entities that may do business with an association for purposes of creating a rebuttable conflict of interest, reference is now made to persons as identified in subsection 101, which includes basically everything: individuals, children, firms, associations, partnerships, joint ventures, business trusts. So basically that phrase or that term applies to pretty much any person or any entity. It's also clarified that the term compensation also means any referral fee or other monetary benefit derived from a person, as we just defined, which provides products or services to the association, and any ownership interest or profit sharing arrangements with product or service providers recommended to or used by the association. So it's become very broad. Basically, if the manager or the management firm is going to be providing or offering services other than the management services or through companies that they're affiliated with financially, that's a conflict of interest which needs to be disclosed. If an association receives and considers a bid in excess of $2,500 for goods or services other than management services, okay, which is or may be reasonably construed as a conflict of interest, then the association must get multiple bids for that. However, it's been clarified that it does not apply to matters that are disclosed in the management contract as a conflict of interest within the meaning of the statute. If an LCAM or CAM firm proposes to engage in an activity that is a conflict under the statute, then that activity must be listed on the meeting agenda of the next board meeting. The board meeting notice must include a description of that proposed activity, disclose the possible conflict of interest, and include a copy of all contracts and transactional documents related to that activity. The proposed activity. If the board finds that a manager or a management firm has violated the statute, the contract is voidable, and the association may terminate the contract by delivery of written notice of termination. If it is terminated, the association is only liable for the cost of the services up to that time, and is not liable for any termination fee or cancellation fee or liquidated damages or any other kind of penalty. Now we're going to talk about mandatory structural inspections for condominiums and milestones. The milestone in the Structural Integrity Reserve Study, as probably everyone who's listening now or watching now, these came into play after the Champlain Towers South collapse. And basically, these are requirements for associations to have a milestone inspection if they're 30 or more years old and 3 stories or more in height. And the Structural Integrity Reserve Study, if they're 3 or more stories in height, to reserve certain money for structural matters. The milestone is basically is for inspections of current substantial structural deterioration, and then to make repairs if that exists. But there's been some changes to both of these aspects of the law, and it's been changing over the last few years since it came into play. So milestone. The milestone inspections, which again, it was for buildings 3 stories or more in height, that's been clarified to mean apply to buildings that have a residential condominium component, and there are at least 3 habitable stories as a term of the Florida Building Code. So in essence, 3 stories that you can live in. So that would not include a parking garage or a parking area. That's not habitable, but it's 3 stories that are habitable. In other words, you can actually live in. A board of county commissioners or the municipal governing body for a city or a town must adopt an ordinance requiring the association, the condominium association that is subject to the statute, to schedule or commence repairs for substantial structural deterioration within a specified time frame after the local enforcement agency receives a phase 2 report. So what does that mean? For the milestone inspections, again, if you have 3 or more habitable stories and you're more than 30 and you're 30 or more years old, we didn't mention that, but it's in the statute, there's a phase 1 inspection, which is visual. If that phase 1 inspection, milestone inspection, indicates there's substantial structural deterioration, then you have a phase 2 milestone inspection, to basically a more in-depth, deeper inspection as determined by the engineer or the architect. And in the phase 2 inspection, there will be repairs that must be performed. So basically, the county or the city, whoever has jurisdiction, then has to basically monitor that those repairs are being performed. A licensed architect or engineer who bids to perform a milestone inspection must disclose in writing to the association his or her intent to bid on any services related to maintenance and repair or replacement, which may be recommended by the milestone inspection. So if that architect or engineer has some kind of relationship with the firm or company that's bidding to do the repairs, that has to be disclosed. Any design professional, architect, engineer, etc., or contractor licensed under Chapter 49 who submits a bid for performing services recommended by the milestone inspection, the phase 2 inspection, cannot have an interest, directly or indirectly, in the firm or entity providing the milestone inspection, or be a relative within a third degree of consanguinity by blood or marriage of any person having a direct or indirect interest in that firm, unless the relationship is disclosed in writing to the association. A contract for services is voidable and terminates upon the association filing a written notice terminating the contract if that design professional or licensed contractor failed to provide the written disclosure of the relationship as required under the statute. Also, that design professional or contractor may be subject to discipline under the applicable Practice Act for his or her profession. So in other words, the governing body for their profession may also impose penalties upon them for violating this conflict of interest provision. The local enforcement agency, as I mentioned, city and or county, or actually city or county or town that oversee the milestones as far as the repairs, on or before December 31st, 2025, and on or before December 31st every year thereafter, that local enforcement agency responsible for milestone inspections must provide to the Department of Business and Professional Regulation in electronic format determined by the department certain information. It must include, but not limited to, what's on your screen there. The number of buildings required to have a milestone within that agency's jurisdiction, the number of buildings for which a phase 1 has been completed, the number of buildings granted an extension of the date by which the initial phase 1 inspection must be completed. The number of buildings required to have a phase 2. Again, you only have a phase 2 if the phase 1 indicates substantial structural deterioration. The number of buildings for which a phase 2 has been completed, the number, type, and value of permit applications received to complete repairs required by a phase 2 milestone inspection, a list of buildings deemed to be unsafe or uninhabitable as determined by a milestone inspection, and finally, the license number of the building code administrator responsible for milestone inspections for that local enforcement agency. Now, some specifics or more specifics about condominium associations. Video conferencing, and this is becoming obviously all the rage or the popularity of it post the pandemic or during and after. Video conferencing, Zoom or other means is now extremely popular, as we all know. So there's video conferencing requirements now with respect to board meetings as well as for membership meetings. So we're going to get into more detail right now. The term video conference has been added to the Condominium Act as a defined term, and it's now defined as a real-time audio and video-based meeting between 2 or more people in different locations using video-enabled and audio-enabled devices. The notice, this is important, for any meeting that will be conducted by video conference must have a hyperlink and call-in conference telephone number for owners to attend the meeting. The third bullet point is also very important. There must be a physical location. There must also be a physical location where unit owners can attend the meeting in person. And I can tell you, I got several questions even before the statute changed like this from owners saying, from board members, my clients saying, can we do a video or Zoom only meeting? And I would tell them even before the statute, no, you still have to have a place, a physical location. Well, that's now been codified. So if you're going to do a meeting by video / conference call, you must also have a physical location where owners can attend in person. Also, all meetings conducted by video conference must be recorded, and that recording must be maintained as an official record of the association. Material amendments to a non-residential condominium declaration. Might not apply to many of you out there, but just to be aware, the declaration of a non-residential, or i.e. commercial, condominium created or formed on or after July 1st, 2025, may be amended to change the configuration or size of a unit in any material fashion, materially alter or modify the appurtenances to the unit, or change the proportion or percentage by which the owner shares the common expenses and owns the common surplus if the record owners of all affected units and all record owners of liens, mortgages and such, on the affected units join the execution of the amendment. The approval of record owners of the unaffected or non-affected units is no longer required. It used to be required for both the affected and the non-affected units. Now it's just of the affected units. More about associations and managers. If an association has a contract with a manager or a management firm, the manager or the firm must possess all applicable licenses required under Part 8, Chapter 468, which obviously just makes common sense. However, bullet point number 2, there's now a duty upon the directors or officers of an association that contracts with a manager or a management firm. They have a duty to ensure that the manager or management firm is properly licensed before entering into a contract. So the board now has an affirmative obligation or duty to basically get proof from that manager or the management firm that he, she, it is properly licensed. If a contract is between a manager and the association, and the manager has their license suspended or revoked during the term of the contract, the association may terminate the contract upon delivery of a written notice to the manager effective upon the date of the suspension or of the becoming unlicensed. If a CAM firm, again, a management firm, has its license suspended or revoked, same thing, the association may terminate that contract upon delivery of written notice to the management company. Official records and website requirements, and the website requirements have changed, and the official record requirements. as it's been changed for a little bit now, minutes of all meetings must be basically kept forever or indefinitely. Video meeting recordings must be kept for a year. Financial records include bank statements, ledgers, invoices, transaction receipts, and deposit slips. That's not really a change. It's always been pretty broad regarding what is financial records. Readily available documents. These are documents that must be made available at their cost. And that's the governing documents, declaration, articles, bylaws, rules, question and answer sheet, the most recent year-end financial statement, that could be audit, review, or compilation, depending on the association, and the budget. And we'll get into more details in the next slides. In addition to the previous official record requirements, the association must now also maintain a book or books or electronic records that contain the minutes of all meetings of the association, the board, and any committees, and any membership meetings, and all recordings that we just mentioned before. If there are approved minutes for a meeting held by video conference, recordings of minutes that are conducted by video conference must be maintained for at least 1 year after the date the video recording is posted. So you have to video record that meeting, you have to post it on the website, and you have to keep it posted for at least a year. Accurate, itemized, and detailed records of all receipts and expenditures, we just mentioned that, bank statements and ledgers, and a copy of all affidavits required by Chapter 718. And there's now even more affidavits than there were before. Affidavits of mailing and affidavits of receipt of certain things, mailing of special assessment notices, affidavits of mailing of the annual meeting, affidavit of providing owners notice about the being able to obtain the financial audit. We'll talk about some of these, but there are several affidavit requirements in the statute. Basically, all those affidavits must be kept part of the records. A director or member of the board or manager who willfully and knowingly or intentionally violates the official records inspection requirements commits a misdemeanor of the second degree, and he or she must be removed from office and a vacancy declared. This used to be required that it be a repeated offense. That's no longer repeatable, or it doesn't have to be repeated. If it happens once, then you're subject to the misdemeanor penalty or the misdemeanor consequence. In addition to maintaining an adequate number of copies of the governing documents and the question and answer sheet, as I mentioned earlier, to ensure that they're available to owners, you also have to maintain the most recent annual financial statement and the annual budget and make those available. You can still charge your actual cost for providing copies of those documents. Website and official records. A document must be made available on the association's website or for download onto an app for a mobile device within 30 days after you receive or create that record. So if it's a record that's required to be posted pursuant to the statute, it must be posted within 30 days of the creation or receipt of that document, of that record. In addition to its previous official record posting requirements, you must also post the approved minutes of all board meetings over the preceding 12 months, the video recording or a hyperlink to the video recording for all meetings of the board, committee, and the owners, which are conducted by video conference, again, over the preceding 12 months. And as I mentioned before, a copy of all the affidavits are also required to be posted on the website. And here's a reminder for everyone, okay, commencing January 1, 26, which is almost here, an association with 25 or more units must have a website and comply with all the statutory website requirements. So that's actually way down from the current number of unit requirements. And now almost every association, except for very small ones, are going to be required to have a website or the mobile app. Criminal penalties and financial reporting. Okay. The legislation, they keep including more and more, I guess, criminal penalties for violations of certain things under the Condominium Act and statutes. So they're clarifying that existing criminal penalties by adding specific intent requirements. So violations must now be committed willfully, knowingly, and intentionally. I'm not sure what the difference between those three words are, okay? But obviously there is a willful and knowing requirement, not just inadvertent or, you didn't do it intentionally. Financial reports, and we'll get to this in more detail in a few seconds. Now the deadline's been expanded from 120 to 180 days to basically finalize and provide the annual financial report. And here's the detail on that. Within 21 days after the final financial report is completed by the association or received from a third party typically being your accountant, your CPA, but not later than 180 days after the end of the fiscal year or other date provided in the bylaws, the association must deliver to every unit owner by U.S. mail or personal delivery at their mailing address, property address, or email address, or fax number provided to fulfill those notice requirements, a copy of the most recent financial report, or notice that a copy of that report will be, as requested by the owner, mailed, hand-delivered, or electronically delivered via the internet to the owner without charge within 5 business days after receipt of a written request from the owner. Now, here's another affidavit requirement. Evidence of compliance with this delivery requirement must be made by an affidavit executed by an officer or director of the association. By the way, not manager, officer or director of the association. That basically you've given either the owners a copy of that report or notice that it will be made available or it will be provided to them. If approved by a majority vote of all the voting interests, not just the majority of a quorum, the association may prepare an alternative report in lieu of the compilation, review, or audit. However, please be aware, you cannot do that in consecutive years. So if you've basically voted, the owners have voted to reduce the financial requirement from an audit to something less than an audit or something less than a review, whatever category you're in, you can't do that consecutively. So if they've done it, if you've waived it 1 year or you've had it reduced 1 year, then you have to do the full report the next year. Investment of association funds. This is kind of interesting because I get questioned about this fairly often. A board shall, in fulfilling its duty to manage operating and reserve funds of the association, use best efforts to make prudent investment decisions that carefully consider risk and in return in an effort to maximize returns on investment funds. An association, including multi-condominium association, may invest reserve funds in one or any combination of certificates of deposit or in depository accounts at a community bank, savings bank, commercial bank, S&L, or credit union without a vote of the owners. I'm not sure if you do it otherwise. You need a vote of the owners. It doesn't say the converse, but these things can be done without a vote. But what I want to raise here is many documents, especially older ones, will specifically have provisions regarding where or how association funds are invested or kept. Sometimes they say they must be kept in a bank or an S&L in the county where the association is located. Sometimes it'll have other provisions. In my opinion, those provisions still control and must be complied with rather than investing the money. Otherwise, I don't think that the statute necessarily overrules or overrides, Kaufman or no Kaufman, those requirements that are in your documents. So, although as this says you can do it prudently in order to maximize returns, in my opinion, the duty of the board is to make sure that money is available, not necessarily to make sure that you have the greatest return. So be prudent, be cautious, be conservative with investment of association funds, and to the extent your documents, address how they must be invested or kept, I would still comply with those provisions. Board meetings, okay. As we mentioned before, board meetings may be conducted in person or by video conference as defined by the statute, and the division, which is the Division of Florida Condominiums, Timeshares, and Mobile Homes, must adopt rules governing the requirements for board meetings. For a video conference meeting, the notice must state that the meeting will be via video conference and must include a hyperlink and a conference phone number for owners to attend the meeting via video conference. And again, as we mentioned before, you still have to have the address in the notice for the physical location where owners can attend in person. The video conferences must be recorded, and as we mentioned before, they must be maintained as an official record of the association. And although it's not here, I'll just repeat it, and also posted on the association's website. Unit owner meetings, as opposed to board meetings. If the bylaws do not provide the location at which the annual meeting of the owners must be held, the annual meeting must be held within 15 miles, and before this was 45 miles, now it's 15, of the condominium property or within the same county as the condominium property. All unit owners meetings may be conducted, and not shall, by the way, may be conducted in person or by video conference. This is interesting. This third bullet point I find interesting. If the annual meeting is conducted, if the annual meeting is conducted via video conference, a quorum of the board must be physically present at the physical location where the unit owners can attend the annual meeting. Again, this is pretty new, and this is interesting because a annual meeting, a membership meeting, is not a board meeting. So generally speaking, typically at a membership meeting, you don't have to have a quorum of the board there because it's not a board meeting. However, now at your annual meeting, if you're conducting it via video conference, then a quorum of the board must also be physically present in that location. If a unit owner meeting is conducted via video conference, the video conference again must be recorded, must be maintained as part of the official records, and an owner may vote electronically in the manner provided in 718.128. This is new. We're going to get to this in more detail in a bit. The division must adopt rules governing the requirements for owner meetings. And now broadcasting owner meetings or broadcasting owner meeting notices on a closed circuit cable TV system services is no longer an alternative to physically posting the meeting notice. Excuse me, budget meetings. Okay. A meeting of the board or unit owners, and usually under most documents, it's the board. Under most documents, I would say, probably well over 90%, maybe more, that I've ever read. But a meeting at which the proposed budget will be considered may be, again, may, not shall, may be conducted by video conference, and the division, again, must adopt rules governing the requirements for these meetings. A sound transmitting device must be used so that the conversation of members may be heard by the board or committee members attending in person and by any unit owners present at the meeting. Then this next part is a pretty big change from what the law used to be regarding budgets that go over a certain percentage. If a board proposes in any fiscal year an annual budget which requires assessments against owners which exceeds 115% of the assessments for the prior or the preceding fiscal year, then the board must simultaneously propose at that budget meeting, before they vote on the adoption of the annual budget, a substitute budget that does not include discretionary expenditures that are not required to be in the budget. And what is that? They don't even define the discretionary versus non-discretionary. But in any event, if they do propose a budget that's over 115% of the preceding, then they have to go through certain hoops. However, the calculation of whether that budget, the new budget, the proposed budget, exceeds 115% of the prior, that calculation excludes reserves for repair and replacement of the condominium property, the structural integrity reserves that are being used to, or the payment for any repair or replacement under the structural integrity reserves, and insurance premiums. And there's a format for that. I'm going to skip to the next slide because I think that goes into more detail. Unit owners must consider and may adopt a substitute budget prior to the board's adoption of the budget that exceeds, again, that 115% threshold. An adoption of that substitute budget requires the affirmative vote or approval of a majority of all the voting interests, unless your bylaws require a higher vote. Again, not a majority of a quorum, a majority of all. Okay. If a substitute budget, if it was required and it's not adopted by that vote, then the board can adopt the annual budget that they previously initially proposed. At least 14 days before a budget meeting in which a substitute budget will be proposed, the board must hand deliver a mail to every owner a notice of the meeting. Now, if your bylaws require a 30-day notice, then you have to do the longer notice period. If your bylaws have a shorter notice time for the budget meeting, say 10 days, and in our opinion, you have to comply with the statutory 14 days. But if your bylaws have a longer period, as I said before, then you comply with the longer notice period requirement. Reserves and SIRS, which is Structural Integrity Reserve Study funding. Okay, so there's different ways to fund reserves and fund SIRS reserves. Okay, they can be funded through regular assessments, special assessments, loans, or line of credit. However, special assessment, a loan, or a line of credit requires approval by majority of all the voting interests. The accounting methods, well, the CERS reserves may be pooled with other CERS items. They cannot be pooled with non-CERS items. And then loans for CERS and then condos subject to CERS may secure loans or lines of credit to fund capital expenditures related to those studies. So there's two loan requirements or two loan provisions here. One is, a loan to actually fund the CERS, and the other is a loan to do the repairs that the CERS have been designated for. And then there's a funding pause, and we'll talk about that in a next slide or two. And the next slide too. Go on to the next one. Thanks, Jeff. By amendment to the term alternative funding method, and this was put in the statute for multi-condominiums in which you have one association or one association that operates two or more separate condominiums. That's known as a multi-condominium. So anyway, there was a provision in there about having alternative funding method to allow them to waive or have less reserves than required if the division has approved an alternative funding method, which, by the way, I don't think they ever have, as far as I know. But anyway, it used to be applicable to multi-condominiums of 25 condominiums. That's now been eliminated, so we no longer have that 25 condominium amount or minimum for this alternative funding method. Reserves must now include any item that has a deferred maintenance expense or replacement cost that exceeds $25,000 or the inflation adjusted amount determined by the division. For years and years and years, this was $10,000. So it's finally been increased from $10,000 to $25,000 as far as that threshold amount. And what this really means is going to CERS and to statutory non-CERS. Statutory non-CERS is roof, paving, painting, and anything else now that costs more than $25,000 on a deferred basis to repair or replace. Again, for years that was $10,000. Similar change has been made to the CERS part for a catch-all. We'll get to that in a second. Membership approval also is no longer required for the board to pause the contribution to its reserves or to reduce reserve funding if the local building official has determined that the entire condominium building is uninhabitable due to a natural emergency, as defined by 252.34. Typically for here, that would be a hurricane or flood. It's our typical natural disasters that cause that kind of damage. An association's reserve accounts may be pooled for two or more required components. However, reserve funding for CERS components may only be pooled with other CERS components. The reason for this is that you cannot use structural integrity reserve study reserve funds for any other use or purpose other than a structural integrity reserve fund item. Okay, so that's why you can't pool CERS reserve components with non-CERS components. All right. The reserve funding indicated in the proposed annual budget must be sufficient to ensure that available funds meet or exceed projected expenses for all components in the reserve pool based on the reserve funding plan or schedule of the most recent structural integrity reserve study. Very important at the bottom here. A vote of the membership is not required for the board to change from pooling to straight line or straight line to pooling method of accounting. Just a quick pickup. A straight line means you have, every item is in its own straight line category, whatever that reserve component may be. A pooled is you can put multiple items together in a pool, and all or any of that money can be used for any of those items in that pool. In a straight line, you can only use the money for that particular designated item. And for years and years, we would tell clients that if you wanted to combine your straight line into a pool, you had to get an owner vote because you were, in essence, voting to use money for other purposes, from designated individual purpose to multiple purposes. But now, and I think this is a good move by the legislature, you can now change from a straight line reserve funding to a pooled reserve funding by a board vote. But as I mentioned earlier, you cannot pool the non-CERS reserve items with the CERS reserve items. Also, If an association votes to terminate a condominium in accordance with 718-117, the members may vote to waive the maintenance of reserves recommended by the association's most recent reserves, which makes sense. If you're going to terminate the condo, it doesn't make a lot of sense to keep maintaining reserves. CEUs reserves, say that 10 times fast. CEUs reserves may be funded by regular assessments, special assessments, lines of credit, or loans. This came about because, since associations were required, to basically maintain CEUs, and CEUs reserves cannot now be waived, except for limited circumstances, or reduced, except for limited circumstances. So owners, many associations wanted to fund them through loans or line of credit. Well, now you can, but if you're going to fund your CEUs reserves through a line of credit or a loan or a special assessment, you need the approval of a majority vote of the total voting interests of the association. I know I've said this before, but that's the total voting interests of the association, majority, not a majority of a quorum. So for lack of a better example, you have 100 units, and if it's one vote per unit, you need 51, assuming all the owners are eligible to vote, you need 51 votes in that sample. A special assessment, line of credit, or a loan secured for these purposes and related details must be included in the association's annual financial statement. An owner-controlled association that must have a CEUs, structural integrity reserve study, may secure a line of credit or loan to fund capital expenses required by a milestone or a CEUs. Okay, again, this is why we just talked about getting a loan to create or fund the CEUs. Now it's getting a loan to actually do the work that's required by a CEUs or required by a milestone. So you can get a line of credit or a loan for that. It does not apply to a developer-controlled association or an association in which the non-developer owners have been in control for less than a year, or an association controlled by one or more bulk assignees or bulk buyers. That line of credit or loan must be sufficient to fund the cumulative amount of any previously waived or reduced or unfunded reserve funding, and the most recent structural integrity reserve study, and funding from the line of credit or loan must be immediately available for access by the board to do that required repair or maintenance or replacement without further owner approval. And here's an exception to not being able to waive or pause the funding of the CEUs reserves or the funding of reserves for a budget adopted on or before December 31st, 2028, okay, if the association has completed a milestone inspection within the previous 2 calendar years, the board, again, with the approval of the total voting interests of the members of the association, may temporarily pause for a period of not more than 2 consecutive annual budgets, reserve fund contributions, or reduce the amount of reserve funding for the purpose of funding repairs recommended by the milestone. So here, the legislature is giving an association the ability, okay, if it has to do milestone repairs, to focus its resources or its funds on those repairs and to pause the funding of the reserves with this approval by the board and by the membership. Again, but these circumstances have to come into play. It has to be a budget adopted on or before December 31st, 28, and you had to have a milestone inspection completed within the previous 2 years. This does not apply to a developer-controlled association or an association which non-developer owners have been controlled for less than a year, or again, to a bulk buyer, or we have one or more bulk assignees or bulk buyers. And then if an association has paused the reserve contributions, then it must have a structural integrity reserve study performed before the continuation of the reserve contributions in order to determine the association's reserve funding needs and to recommend a reserve funding plan. So if it's been paused under this part of the statute, then before you start funding again, you have to have another CEUs performed to make sure that you're funding it appropriately and on track. CEUs requirements. A residential condominium, and this is just a little background, actually this is more of a review, but a residential condominium association, again, residential, not commercial, must have a CEUs completed at least every 10 years after the condominium's creation for each building on the property that is at least 3 habitable stories as determined under the Florida Building Code. A CERS must now include any item that has deferred maintenance expense or replacement cost that which, if not done, will adversely affect the other items, and that cost exceeds $25,000 or the inflation adjusted amount determined by the division. Again, this used to be $10,000, now it's $25,000. And the division must annually adjust for inflation based on the CPI for all urban consumers released in January of each year. So that minimum $25,000 is subject to inflation adjustment, basically. By February 1st of 26, and annually thereafter, the division must conspicuously post on its website what that inflation adjusted amount is. A CERS, including the visual inspection portion of that study, must be performed or verified by a licensed engineer, architect, or a person certified as a reserve specialist or professional reserve analyst by the Community Association Institute or the Association of Professional Reserve Analysts. At a minimum, the CERS must include a recommendation for reserve funding schedule based on a baseline funding plan that provides a reserve funding goal in which the reserve funding for each budget year is sufficient to maintain cash flow or reserve cash flow above zero. The CERS may recommend other types of reserve funding schedules, provided that each recommended schedule is sufficient to meet the association's maintenance obligations. If that study recommends reserves for any item that is not a CERS component, which is listed in the statute, the amount of the recommended reserves for such item must be separately identified in the reserves as an item for which reserves are not required. So again, in the statute, CERS is required for a list of items. It's roofing, it's painting, it's exterior windows and doors if they're maintained by the association. It's electrical, plumbing, fire safety, structural, and anything else that may adversely affect those items which cost $25,000 or more on a deferred basis. Those are your CERS items. If I forgot to say plumbing, I'll throw plumbing in. But if it's not one of those items, then you don't fund it through the CERS. The structural integrity reserve study must take into consideration the funding method or methods used by the association to fund its maintenance and reserve funding obligations, and that whether it's through regular assessments, special assessment, line of credit, or loans. So your CERS and your method of funding must be basically in line with each other and based on each other. If the CERS is performed before the association has approved a special assessment or obtained a line of credit or loan, then the CERS must be updated to reflect the funding method selected by the association and its effects on the reserve funding schedule, including any anticipated change in the amount of regular assessments. The structural integrity reserve study may be updated to reflect any changes in the useful life of the reserve items after the items are repaired or replaced, and the effect that repair or replace has on reserve funding schedules. So obviously, if an item has a estimated X amount of year life, and then an item has some maintenance, repair, replacement done to it, which extends that useful life, then the reserve study needs to be updated to reflect that new useful life, which will obviously reflect or will affect the amount that has to be collected every year for that particular item or component. The association must obtain an updated CERS before adopting any budget in which the reserve funding from regular, special assessment, lines of credit do not align with the funding plan from the most recent version. Like I said, so the funding of the reserves and the maintenance obligations must be in alignment with the way that the CERS study was performed. The two have to be based on the same funding method. In addition to the existing exceptions for having to have a CERS performed, it's not required for a 4-family dwelling with 3 or few stories above ground. Now, associations that were in existence on or before July 1st of 2022 must have a structural integrity reserve study completed by December 31st, 25 for each building on the condominium property that is 3 stories or higher in height. If an association completes a milestone inspection or an inspection completed for a similar local requirement, which is basically similar to substantially equivalent to a milestone, the association may delay performance of a required CERS for no more than 2 consecutive budget years immediately following the milestone inspection, in order to allow the association to focus its financial resources on completing any maintenance or repair required under the milestone inspection. So again, it's a way to allow the association to focus on the milestone without having to fund the reserves. If an officer or the service reserves, an officer or director of an association, not the manager, must sign an affidavit acknowledging receipt of the completed CERS from the party that performed it. So again, remember before I mentioned there's more affidavit stuff or affidavit requirements. This is another one. This affidavit having to be signed by an officer or director and also maintained among the official records. The division must adopt by rule the form for the structural integrity reserve in conformance, in coordination with the Florida Building Commission. Now, there's conflict of interest also with respect to the structural integrity reserve studies. Any design professional or licensed contractor who bids to perform a structural integrity reserve study must disclose in writing to the association his or her intent to bid on any services related to any maintenance and repair or replacement that may be recommended or required by the CERS. Any design professional or a contractor, any design professional licensed contractor submits a bid to the association for performing any services recommended by the CERS may not have an interest, directly or indirectly, in the firm or entity providing the association's structural integrity reserve study, or be a relative of any person that's within a 3rd degree of consanguinity of any person having a direct or indirect interest in that firm, unless that relationship is disclosed to the association in writing. A contract for services is voidable and terminates upon the association filing a written notice terminating it if the design professional or licensed contractor failed to provide written notice disclosure of the interests or relationships. A design professional or licensed contractor is also subject to discipline again under their governing body, so to speak, or their practice act if they fail to provide these disclosures. Hurricane protection, new change under the Condominium Act under 718.113, unless otherwise provided in the Declaration of Condominium as originally recorded or as amended, an owner is not responsible for the cost of any removal or reinstallation of hurricane protection, including exterior windows, doors, or other apertures, if its removal is necessary for the maintenance, repair, or replacement of other condominium property or association property for which the association is responsible. However, please be advised that hurricane protection is defined under the Condominium Act basically as shutters, impact windows, impact glass, or other products which meet current code for hurricane protection. So if there are 30-year-old hurricane shutters that don't meet current code, that does not qualify as hurricane protection under the statute, under this part of the statute. Because what this statute addresses is, before the statute was changed under case law, owners who put stuff out on the common elements like hurricane shutters or things like that, or upgrades, when the association was performing repairs and those things had to be removed incidental to those repairs, it was the owner's cost to remove and to reinstall them. But now, if those items meet current code, unless a declaration provides otherwise, the owner, the association pays for the removal and the reinstallation, not the unit owner. The board must determine if the removal or reinstallation of the hurricane protection must be completed by the owner or the association if the declaration does not specify who is responsible for these costs or for doing it. Evacuation from the property. So in the event there's an evacuation order issued, mandatory or voluntary, in the locale in which the condominium is located, typically for us, that's a hurricane situation, the board can require the evacuation of the condominium property. If an owner or other occupant fails or refuses to comply with the board's evacuation order, then, or evacuation requirement, the association is immune from liability or injury to those persons or to that person or property arising from the failure or refusal to evacuate. electronic voting or emailed ballots. All right, go to the next slide, Jeff. I just want to, okay. I'm going to take a pause here for 1 second. Electronic voting typically was voting online, where the association would have a vote of the board meeting, that board meeting certain requirements, adopt electronic voting, and then owners could opt in, opt out of electronic voting, i.e. voting online, and there was software available for that purpose. Now this has been changed, and here are the changes. It used to be that a board meeting to adopt electronic voting, i.e. online voting, was a 14-day meeting notice requirement. That is no longer required to be a 14-day notice requirement. So presumably now that can be done on the more standard 48-hour notice to adopt electronic voting. In addition, if at least 25% of the voting interests of the condominium petition the board to adopt the resolution for electronic voting for the next scheduled election of directors, the board must hold a meeting within 21 days after receipt of that petition to adopt the resolution if the petition was received within 180 days after the date of the last scheduled annual meeting. Now, this is the even newer stuff. Now there's a provision to allow owners to do electronic balloting. Now that's different than electronic voting. The electronic voting I said was online. The electronic ballot, okay, is an email ballot. Let's explain this. Unless the association has adopted electronic voting. So if you have electronic voting, this electronic ballot thing does not apply. Okay, so if you have online the option or the ability to vote online, then what I'm about to say doesn't apply. But if an association has not adopted, okay, electronic voting, then the association must designate an email address for the receipt of electronically transmitted ballots, i.e. email ballots. An owner may electronically transmit a ballot to the email address designated by the association without complying with the rules providing for the secrecy of ballots adopted by the division. Now, what does the division require to be secret? Election ballots. Okay, there's no other requirement that I'm aware of for secrecy of ballots other than election ballots. The association must count completed electronic ballots that are electronically transmitted to the designated email address so long as the completed ballot has the following: a space for the owner to type in their unit number or his or her unit number, a space for the owner to type in his or her first and last name, which also functions as the signature of the owner for purposes of signing the ballot, the following statement in capitalized letters and in a font size larger than any other font size on the email from the association to the owner. Basically, this disclosure language says you're waiving the secrecy of the ballot. It is your choice. You don't have to waive your secrecy. You can, vote, you can vote otherwise. But if you're voting by basically the electronic ballot, you're waiving your secrecy. I didn't read it verbatim, but that's basically what it says. And if you don't want to waive your secrecy, then attend the meeting in person or, submit your ballot otherwise. Now, this statute, which is 718.128, or part of that statute, doesn't expressly say it only applies to elections. But I know our firm, and at a recent conference of condominium and HOA lawyers from around the state that was held recently, I think the consensus was that this electronic balloting seems to apply to election ballots and not other ballots. That's not crystal clear in the statute. That is the consensus. I imagine this will be clarified some more. The reason that's the consensus is because no other ballots have the secrecy component, have the signature component, the unit number component, things like that, except for election ballots. So, that's why it seems to apply to elections and not other votes, but we'll see. A unit owner must transmit his or her completed ballot to the email address designated by the association no later than the scheduled date and time of the meeting. So actually, it has to get there before the date and time of the meeting. So if the meeting starts on December 18th at 7 o'clock, it's got to be there, by 7 o'clock, December 18th, and not at the time when the vote occurs, which actually could be later, during that meeting. There is a rebuttable presumption that an association has reviewed all folders associated with an email address with the email address designated by the association to receive ballots if a board member, officer, or agent of the association or the manager provides a sworn affidavit attesting to such review. That affidavit, like all the others, must be maintained among the official records. The division's authority, and that's been clarified as to what the division has jurisdiction and authority over, and it is milestone inspections, completion of repairs required by the milestone inspection, the requirement for a condominium association to maintain an insurance policy or fidelity bonding for all persons who control or disperse funds of the condominium association. What does that mean? That means basically to protect your money from being stolen, okay? So that you have to have basically dishonesty insurance or fidelity bonding to protect against that. Condominium board member education requirements, i.e. today, for example, and reporting requirements for structural integrity reserve studies. So these are the jurisdictional items for the division. Okay, on or before October 1st, 2025, which is last month, all associations must create and maintain an online account with the division and provide information requested by the division in electronic format. The division may require associations, again, condo associations, to provide this information no more than once per year, except the division may require associations to update the information within 30 days after any change. And the division must provide an association at least a 45-day notice of any requirement to provide any information after the association initially creates their online account. So what goes into these online accounts? Okay, we'll go to the next slide, Jeff. Okay, the information the division may require from associations is limited to, okay, their contact information. That includes the name of the association, the address of the association, physical address, the mailing address and county of the association, the email address and telephone number for the association, the name and title for each board member, name and contact information of your manager or management firm, if applicable, and a hyperlink or website address of the association's website, if applicable. The total number of dwellings in for each building in the association, the total number of stories, including habitable and uninhabitable stories for each building, the total number of units, the age of each building based on the certificate of occupancy, any construction commenced within the common elements within the calendar year, and the association's assessments, which includes the amount of assessment or special assessment by unit type, including reserves, purpose of the assessment or special assessment, and name of the financial institution or institutions with which the association maintains accounts. Now, a copy of any structural integrity reserve study and any associated materials requested by the department within 5 business days after that request in a manner prescribed by the Department of Business and Professional Regulation. And My Safe Florida Condo program. This is the program that came into effect a couple of years ago, basically where the state was going to help subsidize hardening of properties against storms. So it established it. It established it under the Department of Financial Services for stuff within 15 miles of the coast. In order to apply, an association must have a majority vote of the board or a majority vote of total voting interest of the members. For mitigation grants, the association must have a majority of the board for approval or the unanimous vote of all owners when the building or structure is subject to mitigation. Well, that's changed. A department created form must be provided to all owners before a vote is to occur. The signed disclosure form is subject to the official records, and a result of any vote must be provided to all the owners. Department-approved hurricane mitigation experts must be used to inspect the property and provide reports. The bill provides for who is an approved inspector and what inspection reports must be, and what those reports must include or entail. Associations can choose their contractor, provided the contractor meets the standards of general law, and the association must submit to the department for final inspection within 1 year after being awarded a grant to receive the final grant amount. Now, what are the changes? Here are the changes to the My Safe Florida Condominium program. What has changed? It amends the definition of what a condominium is to exclude detached units on individual parcels of land. And yes, there are some condominiums that are not vertically stacked units, they're detached, but those are not included within the My Safe program. It prohibits an association from applying for an inspection or grant unless it has complied with the milestone inspection requirements and the structural integrity reserve requirements. It prohibits a condominium association from applying for an inspection or grant unless the windows of the property, of the condominium property or association property are common elements, although that would be condominium property, not association property. Provides that only 75% of the owners, rather than 100%, must approve the application for the grant. It clarifies that the grants under the program must be matched on the basis of $1 provided by the association for every $2 that's contributed by the state towards the cost of the project, and revises the amount that may be funded for roof-related or an opening protection-related projects. And those are things like, exterior doors, garage doors, windows, skylights, basically anything that is a aperture on the exterior of the property. And it revises the roof improvements that are eligible for funding. And I think, yes. So that concludes the course.
That was wonderful, Peter. Thank you. The required part for all of you is completed once you go into the chat area, not to be confused with the Q&A, but the chat area, and click on the link that we placed in there a little while ago, about 5 minutes ago, for the required evaluation. I will place it in there once again. So folks, if you have not already done so, and if you do not see the chat area, press the chat button once, simply so it appears. And in about a minute, I'll place the link in there once again. The Q&A part now, it's not required, all right, but you're welcome to hang out. Peter and Courtney will go over a few of the questions. There are too many to cover all of them, but we'll handle a few of them. Again, this is not required. This is something we do as a little added bonus. So while you're doing that, Courtney and Peter, just take a look at the Q&A. Just take a handful of them that are pertinent on topic. And I'll go ahead right now and place the link into the chat area once again. And when Peter and Courtney are done with a few of the questions, I will come back and share my screen and show you how to do the evaluation if you are still on and having some difficulty with it. So Courtney, Peter, back to you.
Yeah.
Hi, Courtney.
Hi, Peter.
I don't know which ones you want to talk about, which ones you want to answer.
Do you want me to read them and you can answer them?
That's fine. I can see them too, but.
And, skip around because some of them are from way back in the beginning. And use your discretion. Make sure they're on topic.
Okay, I'm going to do a couple easy ones that I feel like will be a quick answer. So Linda writes, I am on the board less than a month. Who on the board is responsible for keeping track of all the paperwork Peter is referring to? And this was in the beginning of the class.
All the paperwork in terms of like the official records and that kind of stuff? Yeah,
I think probably the secretary, right?
Generally the secretary, but really honestly, it's almost like a group responsibility. I mean, all the board members have a fiduciary responsibility, all the officers, all directors. Specifically, under most documents, the secretary is the person who is, quote, in charge, unquote, of the records. But at the end of the day, it really is a group responsibility.
And they can designate somebody, right? They can provide the material and say, hey, you're in charge of making sure it gets onto the website.
They can, but at the end of the day, if it's messed up, everyone would be a little bit in the soup. So you can't just abdicate, I don't think, that type of responsibility, although it does fall primarily on the shoulders of, say, the secretary and or the manager. Hi, Courtney. But at the end of the day, it's probably going to be more of a group type because the law doesn't say, it's X person only.
Okay. And a lot of people had questions about the whole Zoom. So John asks, do audio only call-in options for board meetings using an internet app such as Zoom constitute a video conference call?
Well, the way I read the statute, it says video conference is to give a video and call options, both. This is all new, okay? So who knows how this is really going to be interpreted, but I'm reading it literally, and I believe it says a video, I think the language is and, not or, if I recall. Option there.
Gotcha. And then they also had some questions about the meeting minutes. So in the past, minutes had to be filed for at least 7 years. So now is it indefinitely?
It's indefinitely.
Okay, so Ernest asked that. All communications with my other board members is taking place in emails. Are we allowed to meet without owners to sort out issues? That's a loaded one.
Look, it's like $1 million question, and
Yeah.
you can ask 10 lawyers this and get 10 answers and get mad. Unfortunately, I take a kind of conservative view on this. The statute says a gathering of a quorum or more of board members to conduct association business is a board meeting. The $1 million question is, okay, what is conducting association business? I think if you're meeting to set up an agenda and to figure out what you're going to do at the next meeting, I don't think that's a board meeting. Okay. I think if you start talking about in substance about various issues affecting the condominium, even though you're not taking votes on it, I think now you're conducting association business. Is there a real bright line? No, unfortunately. I think you should strive to not meet as a quorum or more if you're doing substantive, talking in any kind of detail or depth about association stuff, association business. I think then arguably you've crossed the line. Now, some lawyers take the position that if you're not taking motions, you're not taking votes, it's not a board meeting. I'm not in that camp. Okay, I'm in the more conservative camp, where, again, if you're just generally speaking about, stuff that you need to address at the next meeting and you're getting organized, I don't think that's a board meeting. But if you start talking in depth about, hey, what about that roofing contract? And you start talking about the roofing contract in depth, I think then you may have crossed the line. How's that for a lousy, ambiguous answer?
But like you said, you'll ask 10 different attorneys, they'll have 10 different answers.
They will on this one.
Yeah, they will. I've heard it several different ways. Just be cautious, I think, is overall.
Strive to be cautious. I mean,
yeah, be
and I
cautious.
realize as a practicality, it's tough because you got to get business done.
Yeah.
And you can't have your hands tied. I get it. I understand. Try to keep it less than a quorum if you can.
Yes. So Carlos wrote, going all over the place because I want to try to get to the later questions too. Carlos wrote, thank you for the information. Can you tell me how many board meetings we need for the year? Are we considering the annual meeting part of a regular board meeting?
No, an annual meeting typically is a membership meeting.
Mm-hmm.
Okay. And I'm trying to remember which statute was changed to the 4 meeting requirement. I think that was in the HOA Act, not in the Condo Act. I could be mixing that up right now.
I think you're right. I feel like you're right. I'm not an attorney, but I feel like you're right. I think it's HOAs have.
I think the HOA has the 4 meeting requirement. It's not in the Condo Act. So I don't think there's a minimum right now for the condos.
Let's do 2 more questions because we're a few minutes past the advertised time already, and then I'll remain on and help everybody with the evaluation.
Okay. Could you please reinstate what the rules are for condominium evacuation for a hurricane?
Well, there's no real rules. Basically, it's that if there's an evacuation ordered in that area, and the board basically informs its owners to evacuate the property, and the owners don't evacuate, then they're immune from liability. So generally speaking, there will be an evacuation order, either through the state or through the local government agency. I think, can the association order an evacuation? But generally they follow whatever whoever has jurisdiction. And if the association orders the evacuation, they got to evacuate. And if they don't, well, you can't force people out. I mean, if they stay, they stay. But the whole point of the statute change was to make you immune from liability if they don't leave.
And then the very first question we got, I want to answer that one. Nancy asked, we are voting as a community to transfer all of our general reserves to our CEUs. If we don't get the required number of community votes, where does the money sit? Well,
you have to have a CEUs, okay? And you have to have the CEUs money. So when you say transfer all of your general reserve to the CEUs, I don't know how their reserves are currently set up. I mean, if they're set up in line items, then I think they could transfer those line items into a pooled CEUs without an owner vote. Okay. And that's what I would do. If they have a pool of CEUs versus non-CEUs, I have to think that one through. Okay. But if they're line items, I would just transfer them by a board vote. But that really depends upon how the reserves are being maintained.
Okay, awesome.
Let's see.
So
There's one I wanted to address because I screwed up and typed an answer on the wrong thing, and I asked her to resubmit it from Linda Landis. She was asking, so sorry about that, Linda. I meant to reply to somebody else. Who is responsible for setting up and maintaining this account? And she posted that at the time when you were talking about the online account with the division that was due in October.
Who is well, the association is responsible. I mean, for either through their manager or through their board, depending on how they're managed, but
Wherever they designate to do it.
yeah, I mean, they just have to get it done. I mean, if they
Yeah.
ask, that's specific, again, there's no specific person, it's just the association has to do this.
Okay, thanks. Yes, Linda, sorry about that. Back to you guys.
okay, I think that's it for questions. If I can just ask one more, because this should be a simple answer. Somebody asked if, just because this was, I can relate to this one. Somebody asked if their manager refers that a landscaping company, is that a conflict of interest?
If their manager what?
If a manager refers like a landscaping company to the board, is that a conflict of interest?
Only if that manager has an interest in that landscape company, some kind of financial interest, their cousin runs it, their brother runs it. If they're just referring one because they like the man, because they think it's a good company, that in and of itself is not a conflict.
Okay. Thank you. Sorry, because I tend to refer companies that I've worked with before that I know do good work, and I think that's the majority of CAMs. So I just wanted
I'm
to
okay
put
with
that out
that.
there.
Yeah, the conflict is more of when there's a financial
Yes.
interest in that company.
Exactly. I just wanted that to be clear to the person that
Okay.
asked that. So thank you so much, Peter.